Did you know that if you bring a lawsuit, a medical malpractice lawsuit in New York, the judge is never going to suggest to the jury how much your case is worth? You want to know what this is all about? Come join me on this walk through the neighborhood as I share with you exactly what this is all about. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so let's say you decide to bring a lawsuit against your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. And now you have a medical expert who confirms that yes, your doctor was careless, yes, his carelessness was a cause of your injury, and yeah, your injuries are significant and permanent. Now, you go ahead and start your lawsuit. The defense turns around and denies all of your allegations. That means that you are now going to go through the discovery process, and you're going to have to provide copies of your medical records to the defense. You're going to have to provide, if you're claiming loss of income, lost earnings, you will have to provide evidence of what you were earning for a couple of years before the malpractice occurred. And now you have to show the defense anything that you are claiming as far as damages. You have to give them documentation to confirm exactly what you are claiming. During the course of the discovery, the defense attorney will have an opportunity to question you, the injured patient. They'll have an opportunity to send you off to a doctor of their choosing to be examined to see how you're doing now. Likewise, we will have an opportunity to question the people who are involved in your medical care and treatment. Will the judge ever go ahead and suggest how much money your case is worth? Well, during the course of discovery, the answer is no. The judge controls when discovery will take place. The judge controls the scheduling of when things will happen. And if there are disputes between the attorneys about what actually has to be exchanged during the course of discovery, now the judge gets involved. But the judge typically will not get to learn all the details of your particular case and will have no clear understanding of the true value of your injuries. But once the discovery process is over and we tell the judge that we're now technically ready for trial, the judge will want to know, is there a chance that we can negotiate this case? Is there a chance we can settle this before it goes to trial? If we can go ahead and start negotiations and each side is working on good faith, then maybe there is the potential of trying to settle this case before it ever gets to trial. In that instance, the judge, after learning more details during these settlement conversations, may turn around to the defense and to us and give his opinion about the value of your particular case. But let's say that these settlement negotiations don't go anywhere. Or let's say that the defense is not interested in negotiating. Now your case goes to trial. When we get to trial, does the judge turn to the jury at some point and say, ladies and gentlemen, you've heard the same evidence and testimony that I have throughout the course of this trial. Let me tell you what I, as the judge, think this case is worth. Does the judge do that? The answer is no. That is not the judge's function in a trial in a civil lawsuit in New York. So you might be saying, wait a second, what does the judge do then? When your case goes to trial, the judge is responsible for running the courtroom. The judge is responsible for telling the jury, for telling the attorneys, for telling the participants exactly what will happen and when as far as scheduling. The judge is there to make rulings of law, to decide what records come into evidence, to decide what testimony is appropriate, to decide what questions are also appropriate that can or cannot be asked. That is what the judge does. The judge makes rulings of law. Once all the testimony and all the evidence has come in, it is now going to be up to the jury to answer a series of questions to ultimately determine whether or not you are entitled to a verdict in your favor. The very first question that the jury will typically be asked is, was the defendant, was the doctor, careless? And the question that they are likely to be asked is, was the defendant, Dr. Jones, negligent? Now, what is negligence? Negligence is carelessness. It's professional carelessness, right? So if it turns out that they find that the doctor is not negligent, he's not careless, that's the end of the case. The case does not go any further, unless, of course, there are multiple doctors, and now the defense will have to ask the same question for each of those doctors. Was Dr. Jones careless? Yes or no? If the answer is no, they'll go on to the next question. Was Dr. Jim Bob careless, or whatever his name is, right? And now they'll have to answer that question. If the jury determines that one or more of the doctors or the hospital staff was careless, they will then go on to the next series of questions. Was that carelessness a cause of your injury? We call that causation or proximate cause. If the jury decides, yes, that there was a direct connection, a direct link between the carelessness and your injury, now the jury will then go on to decide damages. How much money are your injuries really worth? And then depending upon the types of damages you are claiming, they will have to answer each of those questions. So now, before the judge lets the jury go ahead and start answering these questions, you might be thinking, wait a second, doesn't the judge actually tell the jury what he thinks your case is worth? And the answer is no. It is not the judge's function to put a value on your particular injuries. It is not the judge's function to give his opinion about whether you are entitled to a verdict in your favor. That is the jury's function because they are the fact finders. They are the ones to determine who is more credible, who is more believable. They have to determine whether or not you have shown that you are slightly more likely right than wrong than what you are claiming is true. If the answer is yes, then you will be entitled to a verdict in your favor. And then the jury will have to decide and answer a series of questions about how much money they believe you are entitled to receive as full and fair compensation for the injuries that you suffered. So to answer the question, will the judge be deciding or telling the jury how much your injuries are worth? The answer is, no, he won't. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York. You know, I realize you're likely watching this video because you want to see the beautiful scenery. No. I realize you're watching it because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.